Good evening, my dear friends. I would like to invite you to a small talk on the bank customers like minors, partnership firms, with whom the banker has to take special care in dealing with their accounts. Let us go through to the details. At the outset, we are aware that a bank is an institution which is dealing with money, which means the public money. A bank is doing primarily two kinds of services, namely accepting of deposits from the public in the form of savings deposits, fixed deposits, recurring deposits, and home safe accounts. Also paying interest on their deposits, but the rate of interest is a little bit less. At the same time, by collecting deposits, it gets accumulated, and if it is retained with the bank, it will be of no use except itself becoming a burden. Inevitably, the banker will lend the loans and advances to the needy people, and he will charge higher rate of interest on their loans and advances. And with this margin between lending and deposits, he will maintain his staff members, establishment, management, premises, besides serving the society at large. We know that customers of a bank are not all alike. They'll be different in nature. Some people will go for deposit only, and some people will go for borrowing or loans availing. Similarly, a bank will have a largest number of branches in its network, and the types of customers will also be varying from branch to branch. The customers will be either depositors or the borrowers or otherwise general public who are interested in keeping their valuables like gold, diamond, jewelry, and other important documents with the bank for safe custody. In addition to this, the banker is being used as the agent in making payments. Banker will be acting like a paying banker by receiving standing instructions and make automatic debits from the accounts of the customers by debiting their accounts for amounts of rent, insurance premium, loan installment, taxes, telephone bills, electricity bills, and the like. Similarly, some other people may approach the bankers with standing instructions requesting the banker to act as their agent, and here his role will be a collecting banker. So he will be regularly monitoring the collections monthly, like rents, interest on investments, dividends, other receivables, and periodical sundry receipts. And in respect of some others, the banker is serving as a guarantor, especially in handling the foreign trade or in giving some kind of bank guarantees. He'll be giving a surety after obtaining, securing the necessary credit Also, he will be extending letter of credit, which will be useful in the foreign trade. In addition to the above said functions, bankers will also do the general utility services like issuing of drafts, bankers checks, pay orders, and the like. So, by doing all these services, it will attract the customers. So, the customers approaching the bank for different purpose may be as follows. Primarily, the individuals, either men or women, who are above 18 years. Next comes the minors, the people who have not attained the 18 years of age. Then coming to the association of persons like partnership firms and charitable trusts, joint stock companies, and sometimes in joint accounts, married women or illiterate persons, lunatics, drunkards will also join. And in institutional account holders, the joint Hindu families or Hindu undivided families, literary associations, clubs, sports associations, dramatic clubs, educational institutions, and the like, which we call them as association of persons, will join. Now, let us see the special care to be taken by the banker in dealing with special type of customers. Say, for example, minor or married women, lunatic or drunkard persons. Similarly, insolvent persons means who have been suffering losses and whose assets are just below their liabilities. And here liabilities are exceeding and they have become insolvent in the ordinary course. These people are not ordinarily permitted nor competent to open an account with a banker. But however, the banker will entertain their opening of accounts in the names of their guardian or agents or attorneys, otherwise executors or trustees, through which the transactions will be carried on. Sometimes non-personal accounts like partnership firms, association of persons, or syndicates, limited liability partnership firms, non-trading concerns are also opening the accounts. Now here it is for the banker to take special care as a prudent banker while dealing with them, and also it should ensure that such accounts are being conducted as per the legal provisions stated in the Indian Banking Regulation Act 1949. Now, to start with, the opening of an account is a special contract between the banker and customer. Different people will come for opening account, either in their names as individuals and in the names of their institutions. Now, let us look at the minors at the outset. We know that minors are the persons below the age of 18 years. As per the Indian Majority Act, a person below 18 years will be called as a minor, but he can get his account operated with the help of a guardian or caretaker, as he has no capacity to contract with a banker directly. But any sort of agreements entered into by the minors are avoided, and as such, it cannot be enforced in the courts of law. But in few exceptional cases where the agreements are entered into by a minor, either for necessaries or for the minor's benefit, they are said to be contracts and are being enforceable in a court of law. A banker should take all the precautions before opening an account in the name of a minor. Now, a banker may open a savings account in the name of a minor person, but with the condition that the account will be operated by a natural guardian or otherwise the guardian appointed by a court. A savings bank account can be opened in the name of a person and operated by him, provided he has completed 14 years of age. At the same time, the bankers are advised to record the date of birth as provided by the guardian in the relevant books of records and registers for their information. Generally, in a Hindu family, in case a father of a minor dies, his mother will become a guardian by nature. In certain cases, where the mother of the said guardian also dies during the tenure of a minority of a child, here comes the question of the guardian. Here, either the testamentary guardian or otherwise a guardian appointed by the court will operate the account. In the event of sudden death of a minor, the amount remaining in his account and the balance needs to be paid to the particular guardian. But as long as a minor account is running with credit balance, there is no risk for the banker, absolutely. Although the fact that a contract with a minor is void, it is always safe and better to deal with his guardian only, because this will help the banker to recover any more dues or otherwise, if any, which he might have allowed him to avail by mistake. Otherwise, the amount so advanced we cannot be recovered as it is irrecoverable, and also make him liable to return the securities pledged by the minor. Moreover, if a guarantee is given by a third party in case of a debt contracted by a minor is of no avail on the same ground that where the principal debtor is not liable, the surety cannot be held liable. So this is the case where the banker has to take very serious and prudent decision in this regard. Moreover, a minor may be agent. The law provides that a minor can act as an agent of another competent person to a contract, provided his agency is duly authorized by that person. Say, for instance, minor son may make the contracts besides endorsing the checks and bills of exchange on behalf of his father. Similarly, he can as well borrow on behalf of his father, provided if he has a distinct authority granted by his father to do so. The next aspect is a minor as a partner. Indian Partnership Act provides for the provision of a minor being a partner. So it will not prevent him from joining the partnership. So a minor may be admitted into a partnership firm, and also he can take part in the business. But he cannot be held liable for any debts of the partnership firm which were incurred before the minor attains the majority. On the other hand, unless he expressly repudiates the contract of partnership within 6 months of his attaining majority, then it is presumed that the minor has ratified the partnership agreement. After that, he will become liable for the debts incurred by the firm and is already eligible for the profits and losses at par with other partners of the firm. Then, coming to partnership firms. Now, we are doing this business with the association of 2 or more members, but it is minimum 2 and maximum 20. Here, partnership firm is a special customer where it is not individual, it is association of persons. It is defined as the partnership is a relationship between the persons who have agreed to share the profits of the business carried on by all or by any one of them acting for all. Those persons who have agreed to the terms of partnership firm are called partners and collectively known as a firm. A partnership firm usually will have the following features. There will be a written or implied agreement to carry out the business lawfully, and they will do the business with a profit motive. A partner is entitled to share the profits and losses as per the agreed ratio. And in the absence of any such agreement, all the partners are eligible to share the profits and losses equally. In this partnership firm, a partner can play the dual role of both a principal and the agent of a firm. Now, here, the authority of a partner is implied to bind all other partners by his conduct in the ordinary course of his business. The minimum number of members in a firm is 2 and maximum can be up to 20. But in case of a firm which is dealing with banking business, it is restricted to 10 only. Moreover, the liability of the partners in a partnership firm is unlimited. In the event of firm making abnormal losses and is unable to meet the liabilities to be repaid with the assets of the firm, then it is compelled to attach their personal properties to get the debts cleared. So the liability of a partner is unlimited. Now here the banker has to take a special care while dealing with this sort of accounts. So partnership is an implied authority in a firm and is the most significant feature, and each partner is, by holding the share, becomes an agent of the firm. Any transaction entered into by him will be binding on the firm. He has a power to do what is usual and not expected to do the things which are not unusual. However, his implied authority cannot extend the guarantees or for the sureties exercised by him or given in his personal capacity. So let us look at the duty of a banker while dealing with the partnership firm accounts. At the time of opening of an account in the name of a partnership firm, the banker should be good enough to take all the special care and has to ensure that it is only in the name of a firm and not in the individual's name of partner or the partners the account is opened. And if suppose any such account is opened in the same bank, his co-partners are not liable in respect of those transactions made by him therein. And here the duty of the banker is very responsible in case of obtaining the signatures for operating the accounts. Now, the banker has to be cautious in dealing with the formalities like going through the partnership deed, and if necessary, he may request them and obtain a copy of the partnership deed. Thereby, he will obtain a clear-cut mandate as to the signatures of the partners of the firm. Even though any partner can open the account, but the banker should be cautious and all the partners to sign in the account opening application format. It's a safe mechanism and good precaution to the banker as far as this aspect is concerned. Next comes the powers of withdrawals and limits of the amounts in the case of joint account operations. They need to be clearly specified, also recorded and mentioned clearly. In future, if any kind of power is withdrawn, the banker should not honor the checks which are presented after the date, but any partner can countermand the check which is issued in the name of a partnership firm. But there will be some special circumstances which will prompt the banker to be more and more vigilant in dealing with those cases. Suppose when a partner becomes bankrupt, or else suddenly a partner died, or otherwise a partner becomes insane. And also in the event of the retirement of a partnership firm, then he has to deal with very carefully. Let us discuss these cases one after the another. First, on the death of a partner, the Act says that when a partner dies in the firm, the existence of the firm will be automatically ceased and will come to an end. So the legal heirs cannot become the members of the firm automatically. However, they have the right to recover the money which are due to them from the partnership firm. Now, the bankers may continue the account if, as on the date of death, there is credit balance in the account. But suppose if there is debit balance, he should stop the operations of that account immediately and make it under freeze forthwith. But he should secure himself the right of recovery of the amounts of the estate of the deceased partners also in the event of any more dues. Now see the second aspect of a partner becoming bankrupt. Here also the existence of a partnership firm will come to an end automatically, where the bankruptcy of a partner is noticed. Now the banker should refrain from honoring the checks as and when he comes to know of the state of affairs of a partner becoming bankrupt. He can only honor when the instructions on the instruments contain the signatures of all the partners. Then the account may also be continued as long as it is necessary. And as to the closure of accounts at the time of winding up of the firm, where it is getting resolved due to the bankruptcy. The general practice is that the assets of the firm will be transferred in the name of a partner who will be acting with the responsibility of a trustee. Otherwise, the banker will be held responsible, also found guilty for the lapses and for his negligence. So there is a dire need for him to act with utmost care and caution in dealing with these types of cases. The next issue is if a partner becomes insane, where insanity means the state of being unsound mind. It is a peculiar case. Here, the firm will not get dissolved. However, a partner became insane, it is enough and forms a good ground or basis for the dissolution of the firm. But the relatives of that insane partner may also have the right to file a petition in the court of law with a request to direct them for immediate ordering of dissolution of the firm. Then comes the last aspect of our partnership, where a partner is getting retired. It is a peculiar case. Unlike the earlier cases, the existence of partnership firm will not be troubled or altered in any way with the retirement of a partner. It is a normal practice that during the course of the life of a partnership, some people will get retired with prior intimation or by special compulsions, which will make them to leave the institutions with the prior permission of the other members of the partnership firm. Because this will not lead to dissolution, so he has to obtain the willingness and permission of the members before retiring. At the same time, the bankers must be given information about his retirement so that banker will be cautious in dealing with this particular type of account. He also becomes liable for the debts incurred by the firm up to the date of his stay in the firm. Once the notice is given to the banker should open a new account and the a stoppage of earlier account so that the accounts will get settled very easily. So, in the case of retiring partner, it will be also seen that he will be liable for the debts owing by the partnership firm as on the date of his retirement. In case if the assets had been given as a security for the loans and advances which are granted to the firm, the bank account may be continued on the basis of the transactions are being continued, similar to that of those in the case of winding up of a partnership firm. Now, in this session, we have had a clear discussion with the two types of special customers, especially the minors and the partners in a firm, and the banker's duty while dealing with them in detail. Thank you, one and all.